The case of Hilburn versus Interpipe Limited, 112765.
May it please the court, my name is Thomas Warner. I represent Diana Hilburn, who was the plaintiff below and is the appellant in this case. Madam Justice, I'm requesting 2 minutes for rebuttal, please.
2 minutes will be granted. Thank you.
This case originated as an automobile collision case. Diana Hilburn was being driven by her husband home from a visit with her surgeon to pick up a script for pain medications, as she had just had major back surgery 9 days before. As she was heading to her home in Goddard, she was rear-ended by a Texas-owned and operated semi-truck that was on its way back to Texas. This caused extensive injuries to my client's back. She had to have another surgery. We filed a lawsuit. Ultimately, we had a jury trial in Sedgwick County District Court. At that jury trial, the jury returned a verdict for approximately $333,000, and of that verdict, $335,000, of that verdict, $301,000 was for non-economic damages, $150,000 and change past, $150,000 and change future. Of course, the jury was not instructed about the cap on damages pursuant to KSA 6019A02. And so after the verdict, the defendant filed a motion to reduce the verdict down to the cap. Over my objection, the trial court granted that motion, and we appealed to the Kansas Court of Appeals. The Kansas Court of Appeals ruled that there was an adequate quid pro quo as per Miller versus Johnson, which is of course the case that this court handed down not too long ago, where you ruled on the constitutionality of the caps in the context of a medical malpractice case.
Counsel, can I just stop you there? Because I have a procedural question that I need to get settled before we move on to the merits on any of this. In the Court of Appeals, you challenged the application of quid pro quo to right to jury trial.
Yes.
And you also challenged whether there was a sufficient public policy basis for the legislature's substitution of a remedy in the first place.
Yes.
And then finally, you contested the adequacy of the remedy.
Yes.
My reading of your issues here on petition for review before us is that you're only following up on the third of those, that all four of your arguments to us now deal with the adequacy of the remedy. Is that correct? And if that is correct, have you abandoned those other issues? Are we procedurally foreclosed from addressing the two other issues you brought to the Court of Appeals?
I have not abandoned them. Whether I'm procedurally foreclosed remains to be seen. I'm sure this court will handle that, but I still contend that the cap on non-economic damages is unconstitutional under the Kansas Constitution, both Section 5 and Section 8. The Court of Appeals, when I appealed their decision, their decision was based on the finding of an adequacy of the quid pro quo. But your question is very well taken, Justice.
Well, they did address the two other questions, though. I mean, the Court of Appeals said we're bound by Miller on the Section 5 applicability. And then they said we're not strictly bound by Miller on the second question, but we're going to employ the reasoning of Miller, basically, to say that the public policy justification was adequate. Okay, yeah, I think you've answered my question. You didn't intend to abandon them.
No, I did not intend.
You acknowledge there may be a procedural bar because you didn't bring them forward in your petition for review.
I suppose that there could be. I would hope not, but there could be.
Well, you'll agree that on page 2 of your petition for review, you told us what the issues were that you wanted considered, and all 4 of those questions relate to the adequacy of the remedy, which is the third prong, and Justice Byers
Yes.
said. Okay.
Yes, yes. And, but I think on the basis of the Kansas Court of Appeals opinion, I think that they're still wrong, and I think that they do not, their opinion does not meet the Miller versus Johnson test. And basically, Miller versus Johnson teaches us that, at least in the context of a medical malpractice case, we are to consider the adequacy of the quid pro quo remedy. And in the Miller versus Johnson case, this court found that there was an adequate quid pro quo based on the comprehensive legislation associated with the Healthcare Provider Insurance Availability Act and its tie to the CAP statute that goes with it, KSA 19A02. The Kansas Court of Appeals, I think, went way too far in finding that there was a quid pro quo from the federal act pertaining to common carriers and the adoption of the mandatory minimum insurance requirements, the federal mandatory minimums adopted by the Kansas Corporation Commission.
Let me ask you about that, because it doesn't seem like it's as clean an issue as you just stated, because we have a state law that says that the Kansas Corporation Commission is supposed to adopt certain standards, and the standards that they adopted were the federal. So your clients got the benefit had they had economic damage. I understand the non-economic part of this, but on the economic damages, they would have had the benefit of up to $750,000, right?
True.
Okay. And they would have gotten that partly because it's federal law, but there's also state law. So let's focus on that. Why would you take out of the quid pro quo give and take a jointly mandated insurance requirement like this?
Well, because Miller versus Johnson teaches us that we have to get a little bit deeper on the quid pro quo analysis. So I understand Miller versus Johnson, it's not a question of if you have mandatory insurance, therefore the caps apply, and if you don't have mandatory insurance, the caps do not apply. And there was implicit recognition from the Miller versus Johnson decision that some tort litigants will be subject to the caps and some will not. Now, clearly in Miller, you said that medical malpractice litigants would be subject to the cap for the reasons stated, because of the close connection between the cap statute and the legislative act that created the Healthcare Provider Insurance Availability Act and the Healthcare Stabilization Fund. In the context of this case, where we have the Court of Appeals saying that the Kansas Automobile Injury Reparations Act, which was adopted by our legislature in 1974, somehow forms a basis for a quid pro quo for a statute that came into existence in 1988.
Is there anything in that scheme, the scheme we're dealing with, that is comparable to the stabilization fund?
No, because
just requiring insurance doesn't mean the money's going to be there if they're not insured. So there's no, in Miller there was hay being made about the fact that there's a fund there,
right,
for everyone, but there's nothing comparable in this scheme, is there?
That's correct, Justice. There's nothing comparable in this scheme, and the only thing about mandatory insurance from the Kansas Automobile Injury Reparations Act today is the $25,000 minimum limit for insurance in the state of Kansas, which I would suggest is very, very inadequate. But in any event,
And that may be, and if this were just two automobiles colliding in the night, we might get there, but the complicating factor is this motor carrier status.
yes.
So why do we just brush aside the motor carrier? Is it just because there happens to be a federal statute in addition to a state requirement that put that $750,000 into play?
Well, as I understand Miller versus Johnson, there has to be some sort of a historical or temporal, some connection between the cap statute and comprehensive legislation. And we have that in the medical malpractice context. We don't have that in the automobile context, whether it's two automobiles in the state of Kansas or an automobile and an out-of-state motor carrier. That connection simply does not exist. And so if we were to apply the rule of Miller versus Johnson that talks about comprehensive legislation that pulls these matters together, we don't have that in this case. We've got separation and no intent on the part of the legislature to tie a cap on non-economic damages to the Automobile Injury Reparations Act. So based on the ruling in Miller versus Johnson, it does not reach this particular set of facts. Not
So
only
it's just
that,
a partial substitute remedy. It's if they happen to be a Texas motor carrier or a motor carrier, then there's a adequate substitute remedy. But if it's my farm tenant hauling grain to town in his tractor trailer, it's not. Is that?
That's correct. That's correct. And it's going to be a moving target depending on who's involved, the nature of the insurance, if there in fact is insurance, if there's compliance with the insurance law.
Isn't this moving target that you're describing, I mean, isn't that by itself problematic?
I think
when
so.
this court is asked to decide whether a duly passed statute is constitutional or not? I mean, it's not normal, is it? In terms of a methodology for reviewing a statute, where we've got to dive into all these questions of part of a comprehensive act and what was the legislature's motive, and I mean,
I think a better way to handle this would be to not be judicially active in modifying a constitutional right. I think the best way to handle this would to leave the constitutional rights in place and not engage in horse trading with quid pro quo.
not have a quid pro quo rule.
Absolutely. I think the quid pro quo rule, I'm not a big fan of it. I realize that I'm bound by precedent. I'm here in large part because I reviewed the Miller versus Johnson case at some length. I think I have a pretty decent understanding of it. And when you apply those principles to the facts of this case, you do not end up with the same result. But I think a much better approach would be to say that we shouldn't be engaging in this type of analysis to begin with, because ultimately what you're going to end up with, and I think it's implicit from the Miller versus Johnson ruling, there are going to be some tort litigants that are going to be subject to the cap and some that are not. Now in this instance, where we have arguably some form of mandatory insurance, that's analogous to the medical malpractice context. But what happens when I show up here in 3 or 4 years with a tort victim of products liability or premises liability or a dog bite, and there's no mandatory insurance at all? Then where are we on this quid pro quo argument?
Well, I don't think you can throw out the whole quid pro quo, because then we have problems with workers' comp, and I think it goes back to my colleague's dissent in Miller versus Johnson. The quid pro quo has to be a substitute remedy for the person, not
Right.
for the public, not a generic benefit for the public, but something that actually benefits the plaintiff. And here it's not designed for her to be protected in all instances.
That's correct.
Is the situation. But my point being, I don't know that we can say, well, quid pro quo as an analysis, especially under Section 18, needs to go away, can we?
I think that would be hard to do in light of the decision of Miller versus Johnson.
Well, and prior
Previous-
decisions,
previous
and workers'
decisions.
comp,
Historically.
and no-fault insurance, and that sort of thing.
Well, I think so. I think Kansas has definitely decided that the quid pro quo analysis should apply to these types of cases, which is why I'm focused on it. I would like to see it go away. I don't anticipate that it will, and so I'm going to have to live with that. And so I bring this case to this court on a petition for review where we have a completely different set of facts and circumstances than what you had in Miller. And I just think that if you apply the quid pro quo analysis here, you don't end up with an adequate substitute remedy given by the legislature as a quid pro quo for the cap statute under the facts of this case. So when you apply Miller versus Johnson to the facts of Hilburn, we end up with a different result. So I would strongly urge this court to find that the remedy, the so-called quid pro quo in this case, is in fact a fictitious remedy similar to the remedy in Samsel 2, where this court rejected the idea that the trial court did not have the right of remittiture any longer, and that was the quid pro quo in Samsel 2. That was determined to be illusory. I think that when you, as the Court of Appeals did in this case, is when they go back and say, well, the 1974 Act has mandatory insurance, the Federal Act on Motor Carriers requires mandatory insurance, we've got an administrative agency called the Kansas Corporation Commission that says, yeah, we're going to adopt the federal law on mandatory insurance. That's not what we had in Miller versus Johnson. That wasn't the comprehensive legislative scheme that we had in Miller versus Johnson, where the legislature clearly, in conjunction with passing the Healthcare Provider Insurance Availability Act, where they also incorporated the cap statute because of a perceived crisis in medical malpractice insurance. We don't have that with respect to the facts of this case. We don't have that with respect to a Texas motor carrier on its way back to Texas, I think insured in Texas, and we have a situation here where we have a Kansan who was seriously injured by a Texas corporation, and unfortunately, geography matters as far as whether you're able to recover the entire jury verdict. In this case, because this collision took place in Kansas, at the time of this particular collision, the cap statute would apply. Had this happened in a different state, if everybody was the same plaintiff, same truck, same circumstances, same injuries, she'd be able to collect her entire jury verdict in states that don't have caps. But because we have a cap here, we're giving a benefit to an out-of-state trucking company that then forces a Kansan who was seriously injured to not recover her entire jury verdict.
But that's not any different than any of the other procedural rules that vary from state to state, a statute of limitations being the first one that comes off my head. If you have a tort in one state, you may have a longer period of time to bring your lawsuit, or a shorter period of time to bring your law. I'm not sure shorter, but certainly there's some that give you longer periods.
A little bit longer, yes.
But that doesn't seem to strike me as particularly meaningful in this. Just because they're in Texas. I mean, none of us like Texas, but let's put that aside for a second and just say that doesn't seem to enter into the calculus here, unless I'm missing something.
Except from the standpoint that in Miller we were concerned with the actuarial uncertainty for the malpractice carriers. If that's part of our concern here, that we want Texas truckers, motor carriers to have affordable insurance, then the actuarial uncertainty is not ameliorated by our caps, because if they'd been across the line in Missouri, they would have paid more.
They would have paid more.
And so that part of the pretty compelling or a big part of Miller versus Johnson is simply not here, is it?
That's right. There's a major distinction there. And I think that we can draw a lot of distinctions between the facts and circumstances of this case and the facts and circumstances of Miller. It's just not the same. It's not the same in terms of the legislative acts and the historical or temporal tie between the cap statute and the statutes pertaining to automobiles and trucks. It's just not the same thing. And so if the question is, was there an adequate quid pro quo given by the legislature to Diana Hilburn in return for the cap? The answer is no. I think if you look at the legislative history and if you look at the line of cases where the caps have been challenged, I think that you're going to find that when we have a situation where the caps are challenged in an automobile case like this, the Miller versus Johnson analysis simply doesn't apply. I think if you think that there is an adequate quid pro quo, I think it more breaks down to, again, mandatory insurance versus non-mandatory insurance situations. And I don't think that's what the court intended. But there's no adequate substitute remedy given by the legislature.
Except for the no fault.
Except for the no fault, but the no fault.
Have you addressed that? And,
Yeah.
I mean, I understand you're saying 25,000 just simply is too low. That's your argument there.
It's an inadequate.
But if the no fault were 250, you'd have a
That
more
would be a more
difficult-
difficult argument
Yes.
for me. I would agree with that. So it's just simply an inadequate remedy.
Counsel, in the context of quid pro quo, from your perspective, what is the benefit that was taken away by the legislature?
The benefit that was taken away by the legislature.
We're talking, when we talk quid pro quo, we're talking about, you said horse trade.
Right.
If something's taken away, something's given.
Well,
what was taken away?
Her right to recover all of her damages.
To have a jury determine
Have
it.
it.
So, well, those are two different things, right?
Right.
Is it a substantive right to the damages, or is it a right? Is it a question of who decides?
I think it's a substantive right to the damages, a constitutional right to have a jury.
But when we talk about juries, isn't the benefit of a jury really? It's about power allocation, isn't it? It's about who decides.
Yes.
It's not about the substantive law. The jury has to follow the law.
Juries require
And the
to follow
legislature
law.
can say what the law is.
Yeah,
But the jury right is a right to who decides, isn't it?
Right. And we guaranteed that.
And
with
isn't
the
that
Kansas
different? Isn't that
Constitution.
different
I can see
than
that.
the substantive right, underlying right?
Yes, I can see that. I absolutely can see that. And I think that's very important that you bring that up, Justice, because the intention of the drafters of the Constitution was to have jurors decide these issues, not legislators. And I think that's very problematic. Unfortunately, we have the Miller versus Johnson case that I think I'm somewhat tied to. But when you look at and you analyze that case and apply that principles in the analysis of Miller versus Johnson to the facts of Hilburn, we end up with a different result. But I absolutely agree 100% with you, Justice.
I wonder if you shouldn't be careful about what you agree with, because if you recall, looking back past Miller versus Johnson, some of the earlier tort claim cap cases, there were some dissents that said, for example, that the cap doesn't interfere with Section 5 at all, because you got your jury trial. You just
Right.
didn't collect what the jury allocated. And so it seems like you're agreeing that Section 5 is not involved here because you got your jury trial.
No, it's absolutely involved.
Okay,
here.
how so?
Well, because the right to a jury trial, you're asking for a remedy. I mean, Section 5 and Section 8 are tied together because you're going to the
18.
jury. Pardon me?
Isn't it 18?
Excuse me.
5 and 18.
Section 18, I'm sorry, right to remedy. Section 5 and Section 18. But I think that they're tied together because you get your remedy from the jury.
Are there other questions? Thank you, counsel.
Thank you.
May it please the court. Andrew Holder on behalf of Appley Interpipe Ltd. I think, as Justice Breyer pointed out at the start of arguments today, the issue that we're here to decide is whether the Court of Appeals correctly applied Step 2 of the quid pro quo test to the Section 5 and the Section 18 challenges. And it's my position, and I think it's supported in this case, that this case really is comparable to Miller versus Johnson. And I kind of just wanted to walk the court through the comparability and the things addressed in Miller versus Johnson and how they apply here. When we got to step 2 of the quid pro quo test in Miller versus Johnson, one of the things that the majority did was they said, okay, let's start with trying to kind of put the case that we have on the sliding scale of cases that we have for Section 5 and Section 18 challenges. And what the court did was it said, okay, well, the right that was lost here was because of KSA 60-19A02, the amount of the verdict was reduced from the total damages found by the jury. And so they said, well, that on a sliding scale, that's certainly more serious than some of our cases where the legislature has, for example, revoked the right to secondary theories of liability. I think there's a corporate negligence in the healthcare context, and there's vicarious liability. And the court said, okay, well, this is more serious than that, but it's important to note that she still had a cause of action where she could recover damages. So on the sliding scale, it's more serious than that, but it's not as serious as totally revoking her right to seek any remedy, which was the case in some of the decisions like Bonin, where the statute of repose totally barred the cause of action. And so on the sliding scale, it was kind of somewhere in the middle, and I think it's fair to say that our case is in the same boat in that scheme. It's, Ms. Hilburn still had the right to file a lawsuit and to obtain damages. What she lost was her ability to receive 100% the exact amount that the jury determined that she suffered in damages.
Well, another way to put it is what she lost is who decides the amount. She lost the right to have the jury decide and got instead the legislature's decision.
Well, I think that there's a little bit of a distinction there. What the jury under Section 5 gets to do is decide the issues of fact under the substantive law. What the legislature gets to do is decide what the remedy for a cause of action is. So I don't think that the jury...
But once the legislature has said there is a cause of action, that's the substantive law. Why doesn't Section 5 just kick in and say, regardless of what the underlying substantive law is, there's a right to have the jury decide it? It's, again, I called it a power allocation provision earlier. Why isn't that what that Section 5 really is doing?
And I think I understand your question, but if I'm going off on the wrong trail, please interrupt me. What I think Section 5 says is that for any cause of action that existed at common law in 1859 and was triable to a jury then, it will remain triable to a jury now. But what the elements of that cause of action are and what the damages that somebody is eligible to receive are not governed by Section 5. Those are governed by Section 18 to the extent that the cause of action existed in 1859. And so I think that answers the question, but maybe not.
So the legislature could say that, we're going to say that for people injured through someone else's negligence, they can receive 50% of their medical bills. There's no constitutional constraint on the legislature just saying, henceforth, we're going to say all plaintiffs, since they can set damages, we're going to set damages in a tort action at 50% of medical bills, that medical expenses that the tortfeasor caused.
I don't think that that's what I'm saying. What I'm saying is that if the legislature were to do that, that action would not be barred by Section 5. They would, however, still have to comply with that Section 18 to the extent that that was something that was governed by common law, and so then we would get into the quid pro quo analysis.
Since we're on quid pro quo, and I understand your position is we're stuck with it procedurally, given the posture of this case, but indulge me for a second. What is the interpretive methodology by which a court can arrive at the quid pro quo test from the language of our Constitution?
Well, I think that it comes from Section 18 and the right to remedy by due course of law.
Well, what about Section 5? I mean, and again, I'm just asking for, it's kind of a jurisprudential question. I mean,
So
We're interpreting constitutional language, so what methodology gets us from Section 5 to quid pro quo?
separate and apart from the case law that this court has established interpreting it, I think the answer is nothing.
Okay.
If you look at cases like Manzanares, I think what the court said in that case, and it's subsequently been interpreted differently, but in Manzanares it said, the right to trial by jury is the right to have the jury decide the applicable questions of fact under the substantive law as it currently exists. So what I would say, if you're applying, if we've got a fresh slate here, what you'd be saying is, yes, we've still got to comply with Section 18, but if you comply with Section 18 and the substantive law now says that your limitation on non-economic damages is capped at something, that doesn't have anything to do with the fact that with the jury's role in deciding what the questions of fact under the law as it exists are.
Well, I understand that the basis for the cause of action and the issue in Miller versus Johnson was that, and the understanding of the quid pro quo included that there was comprehensive legislation that was enacted to address a crisis in Kansas, and that being the availability of health care. And this was one of the many mechanisms that was used. Was there ever a trucking crisis in Kansas? I mean, where are we at here? What is the connection? Where is this package that addresses a problem with interstate truckers coming in and out of the state? I don't see any connection at all.
And I'll do my best to answer that. I think that I can concede that there is no interstate trucking crisis in Kansas.
Well, and isn't that important?
Well,
in terms of a distinction here?
And that's what I'm trying to get to is, although that's true that there was not a specific trucking crisis, the notion that when these caps were passed, they were focused solely on medical malpractice, I don't think is correct. If you look at the 1986...
At the time these were enacted, they were concerned about other damages as a result of other causes of action?
I think that's true, yes.
Well, I think you need to check your history. I think it was passed with medical malpractice to start with, ruled unconstitutional under equal protection, and then passed as a general tort reform. But go ahead with your answer.
Well, and what I was getting to is that if you look at the 1986 Citizens Committee report, which was one of the things that the legislature primarily relied upon when it enacted 60-1901, it talks about the fact that medical malpractice was certainly the most pressing crisis that they felt like they needed to address. And that was initially addressed in 1985.
There was lots of concerns. I mean, just had to be around at the time. Doctors couldn't afford insurance. Medical malpractice insurance was off the charts, and doctors weren't, according to testimony, doctors weren't coming to the state. Rural places weren't being afforded health care. All kinds of concerns were the motivation, I think, to enact this legislation.
Well, and I think that was initially the very first cap that got passed. I absolutely agree with that. But what I'm saying, and I think it's addressed in the Chamber of Commerce brief and it's addressed in my supplemental brief, is that once the 1985 committee reviewed the medical malpractice issue, in 1986 they were assigned to expand the scope, and essentially they reviewed everything except for medical malpractice. And what they found was that there were liability issues throughout the entire state with employers, with governmental entities, with they reviewed some evidence about car cases. And so the point I think that the point is that while it wasn't specific to the trucking industry, this legislation was intended to make liability insurance as a whole more affordable and more available. And so, can we tie it specifically to the trucking industry? I think the answer is no. But can we tie it to liability insurance? I think the answer is yes.
I'm not going to ask this question well. Let me just start with that. But in my head, the way I've been looking at this case, because it's a motor carrier, is you're analyzing through, you get to the motor carrier scheme of having this $750,000 worth of insurance and whatever else is there. Then below that, you've got no fault, which we all have. And I'm trying to figure out, as you handle a case like this, does no fault even get involved in any of the analysis or effect of what you're looking in your respective claims back and forth, or is it all being dealt with at the what in my tiered system, which may not be the right way to look at it, and you can correct it, are we only playing at the motor carrier level and we never got down to the motor carrier side of, to the no fault side of things? You see what I'm getting at?
I do, and maybe this is an oversimplification, but I think that what you're saying is if motor carrier is at 750 and no fault is at 25, do we care about the 25?
Yeah, but it's also the inner workings of no fault, you know, where you don't have to mess with the other guy, or you've got, you know, other little limits and things. Any of that come to play in your legal fight with the plaintiff here?
Well, in terms of you know, the constitutionality of this cap, I think the answer is yes, and the reason that it's yes is not the 2550 number. It's the fact that when no fault was enacted, that gave Ms. Hilburn the right, regardless of anybody's fault in this, to get personal injury protection benefits. And in Manzanares, that was one of the benefits that the court said was an adequate substitute. And we know from multiple cases that have considered Section 18 that you know, no fault could be an adequate substitute for multiple substitutions, because we know from the healthcare cases that the availability of insurance has been held to be an adequate substitute for.
That was a direct substitution, much like workers' compensation. You couldn't sue the employer, but you got the money from workers' compensation. Here, you have the no fault. You get it from your own insurance company, and that would substitute from the tortfeasors. That's a direct substitution.
Well, I would say that it's a partial substitution, because yes, of course you can get the PIP benefits, but you still have the right to sue.
No, I understand that, but when we're substituting, we're actually substituting this for that,
Directly
not
tied.
the generic right or the generic public benefit or the more likely to have someone to have insurance if they're required to. That's not a guaranteed personal substitute. If this trucker hadn't had insurance, that would have been unlawful, but that wouldn't have been a guaranteed substitution.
Right. If that's true, and I think that would there is a distinction there between healthcare because of the fund and this
things
case.
like workers' compensation, if the employer didn't have insurance, there is a fund.
Right.
There's no fund here for motor carriers that failed to carry the required insurance, is there? Is there a fund you can go to, like the stabilization fund or the workers' comp fund, that pays you the required statutory damages to which you're entitled that was substituted?
There's not a fund. I completely agree with that. I would say that if that were the issue, then you know there are still PIP benefits available. So it's not a total zero, but you know, in the event that there was no insurance or no mandatory insurance, for the trucker, then she would still have her PIP benefits, and so
And that's it. There'd be no other recovery.
that's true.
That's what he's getting at. It's personal rather than public benefit. You heard the question I asked your opponent at the beginning, in fact relied upon his response to say that we were looking pretty narrowly at this case to the third issue he raised in the Court of Appeals. Should it matter to us on that procedural question that you went ahead and argued the other two issues before the Court of Appeals in your supplemental brief? Does that relieve him of his procedural default, that you also procedurally defaulted?
That's a good question, and I'm not sure I know the answer to that question.
That's why I asked it. I wanted to know whether you knew the answer. Okay, thank you.
We've asked several questions. If you'd like to wrap up, we'll give you some additional time.
Okay. Ultimately, the issue that I would like to just simply raise is that the court has held in a number of decisions that The fact that insurance was required, and thus if a judgment is entered, there is a guaranteed source of at least partial recovery for the judgment, is a substantial remedy. And that's what it held in Miller, and it's held that in a number of the other healthcare cases. And so I think that in this case, because there was mandatory insurance from both drivers and it's separate schemes, but the fact that Ms. Hilburn had mandatory PIP coverage, and the fact that there was mandatory insurance for the motor carrier of $750,000 is a sufficient substitute remedy under the court's decision in Miller versus Johnson and all of the other health insurance cases that have found mandatory insurance to be a substitute remedy. I'm happy to answer any other questions, otherwise I'll rest.
Thank you, Mr. Holden.
Thank you.
You reserve 2 minutes.
Thank you. I think that there is a material difference between the mandatory insurance, the health care stabilization fund, and the malpractice setting, and what we have in this setting involving over-the-road truckers. If for some reason the trucking company from Texas did not have insurance, then Ms. Hilburn would not have a guaranteed pocket to get a recovery from. That was instrumental in the Miller versus Johnson case on the quid pro quo analysis. That is simply absent from this particular set of facts. And so I think based on the application of the Miller versus
Explain that to me
Johnson.
real quick. I mean, I understand, or I'm fiddling around with what happens if somebody breaks the law. But in this case, somebody didn't break the law. The law worked. Your motor carrier over there had this insurance. You're going to collect some of it. You may collect a little more of it, but it's there for you. So the system worked. And so why would we want to strike down this scheme or the application of this scheme when it worked for you?
Because the scheme was a part of the comprehensive legislation that was so important to the Miller versus Johnson court. There just simply isn't that type of situation in these facts. We had a direct tie, a historical tie, a temporal tie, and we had the legislature creating this act that mandated the liability insurance in the form of the fund and took away the right of the plaintiff to recover all of their damages on pain and suffering if the jury gave them more than the cap. And I think that's a material difference in this case. Any other questions? Thank you very much.
Thank you. We will take this matter under advisement and